So good morning, everybody. Today we're going to be starting off by talking about Cambodia and the framework for data privacy and data protection. So as for the actual topics we're going to talk about today, there are 5. We're going to start with the legal and regulatory framework for these issues, moving on to some key definitions to understand data privacy. Then we're going to move on to some of the rules for collecting and processing personal data. Then we're going to move on to some of the duties regarding personal data. What are the ways that it should be treated under the Cambodian legal framework? And then lastly, we're going to talk about some sanctions and penalties under Cambodian law related to data privacy and data protection. So the first part, we're going to talk about the legal and regulatory framework. Now, one of the things I want to highlight in Cambodia, when you ask about the legal and regulatory framework, there is a patchwork of different laws of general application that implicate data privacy and data protection issues. So unlike the EU, unlike some other jurisdictions, there is not one main law that sets out all the rules for data privacy and data protection. You have a patchwork of laws. So it's really important to sort of understand what the framework is, and then to understand what are the principles under each of these different laws. And then, as we'll do throughout the presentation, pull all those principles together to come up with like a coherent set of rules that companies can then apply to their data protection and data privacy policies. So to sort of look at the first slide, you have some different laws. So one is the e-commerce law that came out in 2019. That came up with some important rules surrounding like e-commerce and online transactions. Also, if you look at like their laws of general application, you have the Constitution, the Civil Code, and the Criminal Code. And those laws also contain some principles that apply to data protection. So now we're going to look at those laws a little bit more deeply. So starting with like the Constitution, the Constitution really has some key principles related to like data privacy, just like the right to privacy, and how correspondence by mail, and this sort of suggests that the Constitution was drafted some time ago, telegram, fax, those maybe aren't used so much today, but again, those are referenced, like people have a right to privacy when they use those forms of communication, telex, telephone. So I think we can also extend that to other forms of communication that are being used today. Under the e-commerce law, they have a very basic section on like data protection. So it requires companies to protect data. Also, there's certain requirements there where people have a right to correct any incorrect data that's like in the records of an e-commerce service provider. So that provides some basis for at least an obligation to protect data. Under Cambodia's Civil Code, that's really where they set out like key rights. So people have rights to privacy, right to life, right to personal safety, health, freedom, identity, dignity. These are very, very high-level principles. So in some sense, it's maybe difficult if you're trying to craft a concrete policy, but you need to keep these high-level principles in mind just to make sure you don't trip over them when you're crafting a high-level policy. Lastly, under the Penal Code, you actually have some sanctions. So some things are illegal. So recording private conversations and images without consent. So I think that's important there, consent to do these things. Breaches of professional secrecy, that might apply to lawyers, to doctors, to other professionals that are safeguarding data and information. Secrecy of correspondence by phone conversation. Again, a sense of certain kinds of communication should be kept private, certain kinds of information should be kept private. And then it sets out some specific IT crimes, things like hacking and getting into computer systems. Also, we want to highlight, in addition to these laws of general application, the Constitution, the e-commerce law, the Civil Code, and the Penal Code, in certain sectors, there are also some specific sector regulations. So one of the main has to do in the financial sector. So for banking and financial institutions, there are some specific requirements for keeping customer information confidential. So mostly those sort of sector-specific regulations are for banking and financial institutions. For healthcare providers, I think doctors have special obligations to keep information confidential. Also in the telecom sector, under the law on telecommunications, there's also some specific clauses on confidentiality. So I think it's important to just keep in mind, you have these laws of general application. And then on top of that, if you're operating in certain specific sectors, basically banking and financial institutions, healthcare, or telecommunications, there are also some sector-specific obligations that you should be aware of. So now I'm going to hand over this presentation to my colleague, Sochanmalisphoung. So she's going to handle the next two sections.
So I'm going to start with the definition of personal data. Personal data in Cambodia has not been defined, but if we look at the e-commerce law, we see that the e-commerce law defines the term data as a group of number, character, symbol, message, image, sound, video, information, or electronic program that are prepared in a form for use in a database or an electronic system. So based on this broad definition of the data and due to the absence of the definition of the personal data, it remains plausible that the enforcement authority may view all the data of the data subject as the personal data. So let's move on to the next point. It's about the definition of the sensitive personal data. So Jay, can you move to the next slide? So for the sensitive data, it's the same to the personal data. There is no express definition of sensitive personal data. However, if we look at other law that is applicable to other sector, we can see that there are some type of data that are generally considered to be more sensitive in nature, like medical data, financial data, personal data of children, and personal identifier that include the detailed information like your ID card or on your passport. So since there is no definition of sensitive data and it's really hard to understand what considered the sensitive data, it is highly recommended that each data of the data subject should be prudently treated as the sensitive data to the greatest extent possible. So let's move to the next slide. We're going to talk about the stakeholder in the data privacy in Cambodia. As already mentioned by Jay, there is no comprehensive data protection law in Cambodia. Therefore, the concept of the stakeholder in data privacy has not been addressed. However, in general, there are three important stakeholders in the data privacy. The first one is the data subject, refers to the individual who is the subject of personal data, who owns the personal data. And the second one is the data controller, which is the person that collects, use, or disclose personal data. And last but not least is the data processor, which is the organization that processes personal data on behalf of another organization. So let's move on to the next point. After you already know about the stakeholder of the data privacy, now we will focus on the competent authority under Cambodian law. So since there is no comprehensive data protection law, there is also no specific enforcement authority that has with handling, overseeing, implement personal data protection matter in Cambodia as well. However, there are some other governmental body that may have the substantial power over the data protection, including the Ministry of Commerce, that is the competent authority to manage and monitor e-commerce activity in Cambodia. And the second one is the Ministry of Post and Telecommunication, that is the competent authority to control telecommunication, information and communication technology service in Cambodia. And the last one is the Ministry of Interior that has the responsibility to maintain the security and public order in Cambodia as well. So let's move to the next part. So now I'm going to go to talk about part 3 of this presentation, which is collecting and processing of personal data. So what are the requirements to collect and process the data? There are 2 important requirements to collect and process the data. The first one is consent requirement, and the second one is the notification requirement. So I'm going to elaborate further on the consent requirement. For the consent requirement, the organization are required to obtain consent every time before they access, collect, use, process, or disclose the personal data of the data subject. Please note that the consent should be clear, affirmative action. It should be freely given. It should be specific, informed, and unambiguous. So I'm going to give you one example of the one form of the consent, and please look at this example. I believe that all of you already know Adobe Acrobat. So in this platform, you can see that you create an account in order to use this platform or this program. You put your name, you put your date of birth, you put your country, which is your personal data. And if you look at the bottom part of this platform, you will see the sentence that say that if you buy, so the bottom part of the platform say by clicking create the account, you agree that you have read and you accept the term of use and the privacy policy. So this indicates that the organization use a single click method of obtaining consent by informing user that by joining and creating an account, the user is agreeing to the legal agreement, including term and condition or term of use, along with the privacy policy of organization. So you can see that the data subject or the user provide a consent that is clear affirmative action, and they get informed by the organization as well. So let's move to the next issue, which is another requirement to collect and process data, which is the notification requirement. So the organization must also give prior notification to the data subject of the purpose for which it intends to collect, use, or disclose the data subject personal data. So in order to illustrate this point, I'm going to provide the example of the notification policy. So we're going to go through it together. So this is an example of the notification of one company, the information that the organization would like to collect from you, such as your name, email address, postal address, and so on. So for the second main information that I would like to address is here is how we use your personal data. So in addition to the information that the organization would like to collect from you, they also explain the data subject, how they use their personal data. And this part is about the purpose and reason that the organization would like to collect your personal data. So the third point that I would like to highlight is sharing your data. Yes. So here, the organization also notify the data subject and inform the data subjects that who they're gonna share the data of the data subjects to. So in this notification, we can see the important information that the organization use and how they're gonna share this data. So let's get back to the presentation. Okay, so now I'm gonna continue to the cross-border data transfer. So this part is not different from the requirements, the general requirement for collecting or using the personal data. For the cross-border transfer of the data, you also need the notification requirement and consent requirement as well. And now the last part is the rights of the data subject. For the data subject, they have two important rights, it's right to access and right to collect. So the organization must ensure that the data subject have the right to access to the information and also the right to correct and delete their inaccurate personal data. So this is bring me to the end of the part 3. I will hand over to Jay for continue part 4.
Okay. So I'm going to be handling the final parts of our presentation. So now we're going to be talking about the obligations of processing personal data. So as we talked about, there is no specific data protection law in Cambodia. There is a framework and there's different high-level principles that you can pull out of the different laws. So now we're going to talk about what are the obligations regarding processing personal data. Long talked about some, we're going to talk about some others as well, that can be pulled out of Cambodia's existing legal framework. And I think what's really important about these principles is if you are a company and you're trying to craft a data privacy policy or data protection policy, there are not clear guidelines. There isn't a clear data protection law. However, there are these principles, and if you craft a policy that complies with these principles, then you will be complying with like Cambodian law. So I think that's sort of the important takeaway. So as Phuong discussed, and as I'll highlight again, there is an obligation to provide consent. So under certain Cambodian laws, if you don't receive consent to, example, record conversations, that's a violation of the law. So one of the principles we can draw from that is you need to obtain consent from your users before collecting, using, and disclosing their data. So that's a really important beginning to the whole data protection and data privacy framework. Second is something that we call a purpose limitation obligation. So that means once you obtain somebody's consent, you can use it to collect, use, or disclose information for the reason that you obtained the consent. However, if that reason changes and you decide to use the information in a different way, then the consent that you received before is not valid and you should receive a new consent. So if you use information one way and you obtain consent, that's great. But then if you decide to use information another way, you should obtain a fresh consent. The other is the notification obligation. And Phuong just talked about that, so I won't discuss it too much, but you should notify the person how you're going to be using their data. And that's also linked to the idea of consent. You have to notify people how you're going to use their information, and you're going to get their consent for that notification. There is a correction obligation. So under the e-commerce law in particular, you have to give people the opportunity to correct any inaccurate personal data that is in like the company's possession. So people do have a right to correct any mistakes that are made. That also implies an access obligation as well. So if people are to correct any inaccurate information in a company's record, then they really have to have some sort of access to that information so they can see what the record is and they can see whether or not the information is correct or incorrect. So there's also an implied access obligation under Cambodian law. Next, we'll go to number 6, a protection obligation. So companies are required to protect personal data in their possession and to take whatever sort of necessary measures exist to prevent loss, unauthorized access, unauthorized use, leaks, and otherwise. So again, companies have to protect it and they have to use some sort of measures to protect that information. Now, next, number 7, there's a retention obligation under Cambodian law, particularly under the e-commerce law. Companies are required to retain this information, in particular if it gives rise to civil or criminal liability. So companies do have a certain retention obligation. There isn't necessarily a clear time frame for retaining it, but again, any certain kinds of information, if it can lead to civil or criminal liability, companies do have an obligation to retain that information. So those were like just to go back, those were the 7 main obligations for personal data. So again, if companies are crafting policies, it's really good to keep these in mind, to go through them to make sure that your policy encompasses these high-level principles, because if it does, then you'll be in compliance with Cambodian law. Lastly, we'll just talk about some sanctions. I won't read through them. You can see them here on the slide. But there are some penalties under the criminal code and also under the e-commerce law for failing to handle personal data correctly. You can look through these sanctions. And these are the points that you, of course, need to take care of. So I can see we're running a little tight on time, so I won't read through these, but if anybody has any questions about how these apply to your specific situation, please let me know. So that brings me to the end of my presentation. At the end, I'll be happy to answer any of your questions. Thank you. The question is, there's many different types of data. How do businesses know what forms of data are protected under Cambodian law? So I think in answering that question, we would take a look. So in particular, if you're like an e-commerce business, there's a very high level definition of what constitutes personal data. So I think we could look at that definition, and that's extremely broad. So I think, like, practically speaking, I think businesses have to ask, like what kind of personal data am I collecting on an individual? Is it things that could potentially be sensitive? So that's what we talked about a little bit. Is it ID card numbers, phone numbers, address, like personal identifiers? That might be a little bit more sensitive than other forms of data, but all kinds of data could potentially be captured by this. It could be what websites you're going to, how you're interacting with websites, your location data being generated by your phone, other information that you volunteer and give a website. So unfortunately, it's hard to really say this data is clearly protected, this isn't. I think in our presentation, we talked about some data is a little bit more leans towards the sensitive data, where other data potentially would be a little bit less sensitive. But I think that the answer then for a company practically is, I think you need to have terms and conditions which clarify what kind of data you are going to be collecting. You have to clarify what you want to do with that data. And I think that will also then help the company, because you can kind of clarify what data you're collecting. That will be sort of the sensitive data that you're collecting. That will be the data that you protect. And then you won't have to worry as much about other forms of data. But that said, again, I think you need to be very honest with your users what data you're collecting. That's really the basic part. So I think you know what you're collecting. You should sort of define that and make that very clear. And then that will become sort of like the data that you have an obligation to protect. So as we said in our presentation, there is no comprehensive data privacy or data protection law. However, as we also discussed, there are high-level principles set out in a variety of laws of general application that implicate data privacy and data protection issue. So I think the issue for companies is because there isn't clear guidance, you have to sort of look and see what are these principles that exist in other laws, and then craft your policies to comply with those general principles. And I think if you do that, you're on the right side of the law. But at the same time, I acknowledge there is a lot of ambiguity because there isn't one law that sets it all out, that neatly defines what information, what is personal data, what needs to be protected. It doesn't set out very clear requirements for companies. At the same time, although I only very briefly address sanctions, it's also, we're not aware of like any instances of companies being sanctioned for violating privacy policies. So I think that's sort of like the problem, is that it's just not very clear. But again, I think practically you can look at these principles and then craft a policy. As to who would be vulnerable groups, I think there's just a greater risk of like companies misusing the private information or the personal information of its customers because there aren't very clear statutory requirements for companies. So I think, just anybody giving information to a website, that's where there's just like, I think people are just more vulnerable because, many companies, maybe they won't go through all the laws and distill out the principles and then follow those principles. Maybe they'll just say, well, they'll take a lazy response. Well, there isn't a clear data protection law. I guess I can do anything I want. I don't think that's the case under Cambodian law. Some companies might do that. So I think there's just a greater risk that those companies might be then misusing the personal data of its customers. Okay, so clearly the significance would be it would add clarity to this space. So if there was a specific law, hopefully it would define clearly what is personal data. It would set clear obligations on companies, so companies would know what they need to comply with. And then I think also from users, they would be more clear on how their data will be treated, whether companies will actually be protecting their data, and then hopefully setting some sort of procedure for what happens if companies fail to violate, or companies fail to protect data, they fail to follow these procedures, then there'd be some sort of process. There'd be some penalties. There might be some sort of opportunity for customers to notify some sort of data protection authority that their data is being misused, and then that data protection authority might come in and like help them. So certainly having a clear law would really benefit everybody involved, just because it'd add a lot of clarity to this space. I think it's very difficult. That's a good question. I think companies, what they should be doing is to protect themselves, is to be setting out clear policies that comply with these broad principles. And then, I think really the basis in Cambodia, but really in pretty much most jurisdictions, is some sort of concept of consent. I mean, companies should obtain consent of their users on how they're going to be using their data. So I think companies or websites need to have clear terms and conditions. They need to have some sort of data privacy policy, and then users should be able to review that policy, and then they should provide some sort of affirmative consent. They've read it, they click a box, they approve something that says that I agree to be bound by these terms and conditions, and then companies should follow those terms and conditions. So I think practically that's what people should be doing until there's a new law in effect.